Hi, class. This is obviously a kind of strange situation, but we are going to be doing a series of lectures for you guys. I'm sorry we cannot do it as a classroom. As you know, I really love it that when we get interaction, we get to start to argue with each other, and to me that's the fun of a lot of these classes. So I hope you'll bear with me in terms of having to accommodate the situation and do a lecture without any interaction. Another thing I wanted to tell everybody is make sure you stay safe out there. And this coronavirus is not a hoax. So if anybody's telling you it's a hoax, that's not true. Please be safe and keep your families safe. And hopefully at some point I'll get to see you before the end of the semester, because this being my last semester, this is a real difficult situation for me, because I don't have an opportunity to say goodbye to many of you. All right. What we want to do today is talk about a new topic, gender discrimination. And in talking about that topic, we have an outline here for you of the various kinds of issues that we're going to talk about today. And as you remember, I asked you to read about gender discrimination. And just to remind you about the readings, if you look at your syllabus, and hopefully you all have your syllabus, this is Roman numeral number 4. And I asked you to read Lundgren and Taub, chapter 1, pages 1 through 34. For our next lecture, which is going to be a legal analysis of gender discrimination, please read the Epstein materials, 652 to 671, and Lundgren and Taub, pages 37 through 73. What we're going to do today is we're going to provide you a general introduction and overview to this whole new topic of gender discrimination. And when we talk about gender discrimination and we think about it from an historical perspective, what we're talking about here is the perception of gender as a basis for including or excluding a person from a right, an obligation, or a service. And this idea of gender discrimination has changed over time. The legal status of women, as we know, has witnessed significant transformation, for the most part for the better. But having said that, what we have to recognize is even in our modern society, there are still many problems. I mean, just think about some of the things that have been in the news. The Me Too movement, dealing with sexual harassment by Harvey Weinstein, who was just in prison for, what, about 30 years, I think it was. And by the way, he just tested positive for the coronavirus himself, so God knows how he got that. So the Me Too movement. The fact that over the last few years, 3 members of Congress had to resign because of sexual harassment. Greta Carlson and Megan Fox, who had all the problems and resigned from Fox News, and they just have a movie that came out about that not too long ago. I think it's called Bombshell. And one of the things I want you to do as a homework assignment is I want you all to see the movie Bombshell and give me a 1 to 2 page summary on D2L. There are religious components of this too. So when you talk about gender discrimination, there's a religious group called the Promise Keepers. And the Promise Keepers believe very strongly that many of the problems that we have in our society are due to the fact that women are not playing their usual deferential role, which is undermining our society and undermining families. So as you can see, this whole issue of gender is having a major impact even today. As we said, it's improved, and we're going to show how it's improved. But it's still an issue. We still have issues of harassment, abuse, glass ceilings, stereotypes. And within this context, I want to read you something. There was a document that said the following: equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex. And I want to ask you, do you know what document that refers to and what its legal status is in our society? And I want to read it again. Equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex. Now that doesn't seem to me to be a very radical doctrine. And when I've asked students in the past where they think that came from, they tell me the Civil Rights Act, they talk about 19th Amendment, but it's not either of those. That exact language was proposed over 40 years ago in the United States Congress as a constitutional amendment that would provide women with legal equality in all issues. And guess what happened? Until today, we haven't had enough votes to pass it. So it's not the law of the land. It was considered, and is still considered by some states, as too controversial. As a matter of fact, the Associated Press did an article just a week ago in which they said that 5 states seek to block the reintroduction and the passage of the Equal Rights Amendment, as it's being referred to and has been referred to when it was first proposed. So just to give you an example of the 5 states, Tennessee opposes it, Alabama opposes it, Louisiana opposes it, Nebraska opposes it, South Dakota opposes it. And we have not been able to get 38 states to support it. And that's what it takes to pass a constitutional amendment. So that one sentence has not been embraced by our society. And I want you to think about that. What is so controversial about that statement? And I think to really understand why that's considered controversial by some, we have to understand the historical context of the issue of gender. And in talking about that, the first thing we want to talk about is what we refer to as the patriarchal tradition. And what is patriarchy? What is it? So patriarchy has been defined as the manifestation and institutionalization of male dominance over women and children in the family and in society in general. By definition, patriarchy implies that men hold power in all important institutions of society, and women can be deprived of access to such power in many circumstances. And the circumstances we said have changed over time. But we're talking about things like religious issues, cultural issues, political issues. And this patriarchal approach has dominated Western culture for thousands of years. And as part of that, it has been legitimized and institutionalized by our legal institutions. And as we've said, the law is very important in the area of discrimination. And the law is an important instrument for gender-based relationships. The law authoritatively determines our rights and our obligations to each other. So what we want to do is look at the United States and gender. United States and gender, this history. And when we talk about this history, our history of the definition of the role of gender in our society was greatly influenced, as were many things, by England. And just before the American Revolution, William Blackstone, who is considered to be one of the most significant legal scholars in Western civilization, produced a recapitulation of what he referred to as the common law of England in regard to the roles of men and women. And this approach, Commentaries on the Laws of England, was embraced by legal scholars as the appropriate standard to apply. So it had a major impact in regard to the definition of the roles of men and women that was relied on significantly by our founding fathers in the United States. And therefore the legal arrangements going back to our colonists reflected and reinforced the division of labor that it provided for, and rights along gender lines that called for the subordination of women. The subordination of women as it was in Europe. And what we have to understand, at the inception of our nation, when you look at the Declaration of Independence, when you look at the United States Constitution, it didn't provide many rights for women. And according to Blackstone, that's fine. So women were rarely allowed to participate significantly in political, economic, religious, or community affairs. And the legal concept which reinforced this was this notion of the doctrine of coverture. And based upon this legal principle, the doctrine of coverture held that the husband was considered the lord of the manor, and that a husband and wife, when they are married, are viewed legally as one person. So a bonding. And that one person was the husband. The wife loses their entire identity upon marriage. I guess supposedly because she should be so happy that a man decided to marry her. I mean, which leads to even the old concepts of this notion of dowry. So in the old days, if you were a woman who was contemplating marriage to a man, your family had to provide a dowry, a bounty, possessions, to your prospective husband so that would entice him to marry you. That's what a dowry was. So once you're married, the plight of women was even worse. First of all, they should just feel so totally enthused that their husband was willing to accept them. But as we said, by marriage, the husband and wife were considered one person. And that is that the very being or legal existence of the woman is suspended during marriage. Suspended during marriage. Or to put it a little differently, or at the very least, incorporated and consolidated into that of the husband, under whose guidance, protection, and cover she performs everything. And I mean everything. As a matter of fact, according to the law, a man couldn't even grant anything to his wife. For that grant of anything would be to suppose her a separate existence, which is illegal. Women cannot exist separately. They do not have their own identity, according to Blackstone and his concept of coverture. In addition, any compacts made between a husband and wife before they're married, or when they were single, to put it that way, was voided by the marriage. So the contracts had no legal significance. If a wife is injured in person, in other words, bodily, or property, she can bring no action for redress without her husband's concurrence. And even when she is injured and he concurs, it has to be brought, this legal action, in his name as well as hers. It cannot be brought independently. And neither can she be sued without making her husband a defendant. So if you sued the wife, you were suing the husband. Now, in criminal prosecutions, interesting enough, according to the law, the wife can be indicted and punished separately. So that's kind of interesting. The belief was that marriage, or this union between the man and the wife, is only a civil union. So we don't want to have to make the husband responsible criminally. So if the wife does something wrong, then it's the woman's fault at that point. And in a trial of any sort, a wife is not allowed to provide evidence against her spouse. So though the law considers the man and a wife as one person, there are instances in which she is separately considered inferior to him and acting by his compulsion. All deeds and acts by a woman or a wife are void as individual acts. And as part of this belief that there's one entity, and it's the husband, Blackstone said that pursuant to this, the man has to exert his rightful role. And what's his rightful role? Well, the husband must give his wife moderate correction, according to Blackstone, for as he is to answer for her misbehavior, it is reasonable to entrust him with the power of restraining her. He said this relationship between a husband and wife is analogous to that of a father and his children, or a master and his servants. So as a result of curvature, when women marry, control of their property, their owning, their earnings, their businesses, pass to their husband entirely. So they lost all their property, they lost their earnings, they lost their individual identity. And as we've already said, they're already restricted from participating in political affairs. So this provides us with the historical background and belief system and norms and morals that define the relationship between men and women, and in particular, husband and wife. Now, many women didn't think this was a great idea. Can you blame them? There were many women who opposed these ideas, saw them as repressive, had been able to gather individually great wealth, all to be taken away if they wanted to enter into marriage. So for some women, the idea was don't bother getting married. It's only surprising that more women didn't feel that way. But one of the reasons more women didn't feel that way is because the system was instituted in a way that it was very difficult for women to succeed anyway. They were barred from numerous occupations and professions. But a movement does develop among a number of women, and they start to try and challenge some of these early concepts that preceded our Declaration of Independence, that preceded the U.S. Constitution or our Constitutional Convention. And within this context, probably one of the most interesting dynamics dealing with the Declaration of Independence and the United States Constitution was this relationship between Abigail Adams and John Adams, one of our most prominent founding fathers. Abigail was considered a radical at the time. She had very strong beliefs about the need for gender equality. So, while John Adams is involved in helping author the Declaration of Independence, she writes him a letter on March 31st, 1776, and she says, "I long to hear that you've declared an independency." I mean, obviously she's talking about this document which was going to declare independence of the colonies and what we now refer to as the United States from England. She said, "I long to hear that you've declared an independency. And by the way, in this new code of laws, I desire that you would remember the ladies and be more generous and favorable to them than your ancestors." So she's saying, well, you're condemning the British for how oppressive they've been to you guys. Also condemn them for being oppressive to women. Radical idea. She continues, do not put such unlimited power in the hands of the husbands. Remember, all men would be tyrants if they could. So she didn't think too much about men and their natural dispositions. She said if particular care and attention is not paid to the ladies, we are determined to foment a rebellion and will not hold ourselves bound by any laws in which we have no voice or representation. This is radical stuff for the time. I mean, think about what she's saying here. She's threatening an uprising of women, a revolution. She then concludes that your sex are mutually tyrannical is a truth so thoroughly established as to admit of no distaste. She says, willingly give up the harsh title of master, which is what you legally define yourself as. Willingly give up this harsh title of master for the more tender and endearing one of friend. Pretty straightforward. Well, 4 days later, John Adams, her husband, starts to write a response, and then finally sends it to her, and dates it April 14th. And his response is the following. To Abigail, he says, you are so saucy. Well, that's pretty funny language. You're so saucy. What's wrong with you? Calm down. He goes, I won't blot it out. Well, that's nice of him. But then he says, depend upon it. We know better than to repeal our masculine systems. And although they are in full force, you know they're a little more than theory. So I say, yeah, you know, we're dominant. We rule the roost. We have a superior position in society, but it's only theoretical. Really? He says, we dare not exert our power in its full latitude. We have only the name of master, and rather than give this up, which would be completely subject to us to the despotism of this petticoat, we will enforce it. He says, God forbid we let women have an ability to tell us what to do. And by the way, it's just a theory. Really? This is just a theory? No, it's not. It's the law of the land. It's the law of the land. So, in May of that year, Abigail responds to her husband again. And I'm not going to read the whole thing, but what she basically says is, quote, I cannot say that I think you are very generous to the ladies. For whilst you are proclaiming peace and goodwill to men and emancipating all nations, you insist upon retaining an absolute power over wives. So that was the general discussion. And the Declaration of Independence is written. And and published. And ultimately, it doesn't mention anything about equal rights based upon gender. It completely ignores that question. So then we go to the United States Constitution, the Constitutional Convention, in which there was another great debate, over which Abigail Adams wrote more letters. And again, what we see happen is that the 55 men of the Constitutional Convention completely ignore, for any type of gender equality, and more than that, ignore any sense of providing any rights to women. In fact, if you look at our original Constitution, women were not given any rights by the original United States Constitution. So Adams and our founding fathers again ignored the adamant requests of Abigail Adams. The Constitution did not give women the right to vote or acknowledge their legal rights in any way. And as we'll find out, it wasn't until the 19th Amendment was passed in 1920 that women finally gained the right to vote. And as a result of our Constitution, we had a legal approach that fostered and embraced gender discrimination. Women were not allowed to practice law, to own property, to hold public office, to participate in politics. And there were different standards, morally, criminally, sexually. So it's against this backdrop of the most important historical legal documents for our nation, Declaration of Independence, United States Constitution, that women attempt to assert their rights. And there's numerous examples of this over time, but the most significant